Hello and welcome to this episode of Parley, the Hindu's weekly podcast. I'm Aaratrika Bhaumik, your host for today. The question for this week is: should the executive possess clemency powers? United States President Joe Biden's decision last week to pardon his son Hunter Biden for any federal crimes he committed or may have committed between January 1st, 2014 and December 1st, 2024 has brought renewed focus on the expansive clemency powers granted to the president by the US Constitution. Hunter Biden was convicted by a court in Delaware last June of lying on a gun license application while grappling with cocaine addiction. He was later convicted of separate tax evasion charges in a court in California. The president's volte-face has provoked strong condemnation from both Republicans and Democrats, with Biden justifying his decision by claiming that his son was the target of an unfair prosecution. To discuss this contentious issue, we have with us today Mr. Sanjay, a senior advocate based in Delhi, and Mr. Alok Prasanna Kumar, the co-founder and Karnataka lead of Vidhi Center for Legal Policy. I welcome you both. Thank you so much for joining us today.
My pleasure.
My pleasure.
Let us begin this discussion by addressing the key question: should clemency powers rest with the executive? Or do you think it is more prudent to vest this power in the legislature, for instance, to prevent any misuse for corrupt or self-serving ends? Mr. Hegre, if you could please go first.
Well, if you vest it in the legislature, it could be equally corrupt, then it will only be subject to majority rule. The point is, pardon power is something that exists in the executive, or basically in the old days, the ruler, quite apart from the normal legal processes. You may find somebody guilty, but it was always held as an incident of sovereignty that the king could pardon any wrong. And so today we do not have kings. We've come to democracies guided by constitutions, guided by limitations. But even the constitutions recognize that there are certain situations where you have to trust the holder of a high office to exercise the pardon power when necessary. You know, there's a curious thing that the president tests his pardon power, or rather exercises his pardon power every Thanksgiving by pardoning a turkey. So the pardon power is used not only for humans, but for other creatures as well.
Right, Mr. Hegre. Mr. Kumar, do you agree with Mr. Hegre on this? What is your opinion on this?
I fully agree. And let me add a little bit of historical context. This was not an uncontroversial provision of the US Constitution. When the Constitution was being debated in the US, or rather it was sent to the states for ratification, this needed to be publicly justified. And Alexander Hamilton, who wrote the Federalist Papers, which essentially defended and made the argument for the US Constitution, addressed this exact issue in Federalist Paper number 74. And he makes a very interesting argument. Which is to say that sometimes responsibility has to be given to one person for whom this is a big deal, right? I'm paraphrasing it. And he talks about how this power is going to have to be used in a political way. He doesn't think that it is just a purely legal exercise. He offers two justifications, and both those justifications, in my view, hold well. Number one, there are going to be political situations where you need to use this power. And, in his wisdom, Alexander Hamilton has been proved right, because there were two political situations, and these are the two most famous examples, where this power of pardon was used against people who you could say have been treasonous against the United States. Number one, Confederate soldiers after the US Civil War. Number two, draft dodgers after the Vietnam War. So he understood and he defended it on this explicit ground, this is a political power, and this power, or rather, this is a power which has political dimension that should be exercised by one person. It should not be a question of committee. It should not be done by committee, in which case nobody will take responsibility. One person will have to take responsibility and do this. The second point that he sort of makes is on the question of mercy. He says the rigors of criminal justice sometimes need to be tempered with mercy. And, those of us who have read Merchant of Venice will know Portia's famous speech, on the quality of mercy. And I'd like to read out a couple of lines to identify exactly what I mean. Is mightiest in the mightiest. It becomes the throned monarch better than his crown. His scepter shows the force of temporal power, the attribute to awe and majesty, wherein doth sit the dread and fear of kings. But mercy is above this sceptered sway. It is enthroned in the heart of kings. It is an attribute to God himself. And earthly power doth then show like his gods when mercy seasons justice. So the idea being that this is not just there's a political element to it, but there is also an element where as a society, we believe justice should be tempered by mercy. And this idea of justice being tempered by mercy, of course, can sit in other places. No one is saying the only person who can show mercy is the king. I think that is what has changed of an absolute monarchy becoming a constitutionally governed rule of law democratic system. So it can sit in different places, but it doesn't take away the fact that the ultimate executive authority can also exercise this power to show mercy. So in that sense, I see these two justifications as perfectly good reasons to have this power of pardon sitting with the top executive authority.
Right. Thank you, Mr. Kumar. Like both of you have mentioned, that you have the US Constitution explicitly grant this power to the president, and both of you agree that it should reside with the executive. But there has also been growing activism recently around the fact that there has to be more transparency in the process. Do you believe that reforms are required in the clemency process, especially when it comes to the constitution of, let's say, an independent clemency board or a commission comprising of independent experts who could guide the president when it comes to these clemency applications? Mr. Kumar, what is your opinion on this?
As I understand it, and again, I'm not an expert on the minutiae of the US system, the Department of Justice in the US federal system makes a recommendation on this front. They put all the materials before the president, and they usually give the advice to say, should we give clemency or not? But it's not binding. Because let's keep in mind, and since we will be talking about this, there is a fundamental difference between the Indian system of clemency and the US system of clemency, even though in name it's the president who exercises this power. In India, the president is exercising this power solely on the aid and advice of the cabinet. Whereas in the US system, the president is all powerful. He or she is not bound by the advice of the cabinet or a specific department. So yes, the president can say, please give me all the information. I would like to know on what basis. But at the end of the day, and as Harry Truman famously said, the buck stops with the president. The president is the one who has to take the call. So all the transparency is great. And I suppose in this day and age, with social media and with the free and vibrant press, everyone will know all the reasons why the US president has taken this decision. But that doesn't mean every decision will be immediately acceptable to the public at large.
Right. Mr. Hegre, do you agree with Mr. Kumar on this?
Well, the public doesn't always like decisions on clemency. The most famous example was when President Ford pardoned his predecessor, Richard Nixon.
And I decided that was the only way I could get rid of Mr. Nixon's problems that were taking 25% of my daily time, so I could spend 100% of my time on the problems of 230 million Americans.
You must remember that Ford had not been elected as president. He had not been elected even as vice president, but he was chosen after Nixon's previous vice president, Spiro Agnew, who resigned. And so when he succeeded Nixon to the presidency and he pardoned his predecessor, it was almost seen as being thank you or a reward for what Nixon had done for him. And consequently, Gerald Ford lost the 1976 election to Jimmy Carter. But Ford had this justification that the country had been through too much during the Watergate hearings and that the matter should now be put to rest because Nixon had been punished enough by losing the presidency. A criminal trial would only the agony of the country. He had his justification. And the then special public prosecutor, Jaworski, refused to challenge the exercise of presidential power in this manner. This gets back to what Alok was saying, that Hamilton envisioned that this was necessarily a political power and sometimes to be used in political circumstances. That being the situation in the US, India is somewhat different. As Alok told you, that we do not have an executive president. We have a president who acts upon the aid and advice of his cabinet, and similarly for the governor. So there's a Supreme Court judgment in the case of called Epuru Sudhakar, Justice Pasait's judgment, if memory serves me right, where the governor's power of pardon in such circumstances was greatly circumscribed, and the Supreme Court actually struck down pardons which were issued by the governor, where they could not find a justifiable basis for it. I do not think that as far as US law goes, the pardoning power is capable of judicial review. That's the basic difference between India and the US.
Right, Mr. Hegre. Since we are speaking about judicial review, do you think that, of course, now the jurisprudence in the US has not developed to that extent, but do you feel that an expansive scope of judicial review could, let's say, prevent pardons which are politically motivated? You think that would help? Do you think an expansive power of judicial review is required in such cases?
Well, one man's use is another man's abuse. At least I don't think we'll ever see the US moving to this system, or at least not in the immediate future, because no sooner that Trump comes into office, that he is going to use the pardon power extensively to get to pardon possibly the January 6th rioters and a whole host of other people. There is also talk that Joe Biden on the way out is going to pardon a whole host of people preemptively so that Trump does not prosecute them later. So we are, if anything, in a situation where there is going to be an explosion of clemencies and pardons on the president's part. And I don't think the judiciary in the US is going to rush into second guess the authority of the president. In India, as I've told you, everything is up for judicial review, and more so when presidents and governors are bound by cabinet advice. So I do not foresee that in India, at least, there can be too much of an abuse of the system. If anything, it is the argument often is that in exercising the clemency powers, the president must exercise his or her wisdom in addition to cabinet advice. That is a line of argument that some people in some cases have sought to deal with. But so far, we have not directly had any such use of clemency powers. All that presidents have done at times is to exercise a pocket veto on these files. So I believe President Abdul Kalam just sat on files which had come up to him for rejection of mercy. He asked a particular question, asking why is it that it's only the poor people who are subject to the death sentence. And thereafter, all files in this regard, notes were completed, everything was completed, but it remained on his desk. That situation also continued with President Pratibha Patil, who also had some religious and spiritual objections to the death penalty. It was only when President Mukherjee took over that he dealt with it like any other file. Whatever file was put up to him, he used to sign it. So the pardon jurisdiction in non-capital offences in India have been very rarely used. It's only in capital offences that they seem to be used. I don't think there have been very many great abuses which have called for judicial review.
Right. Thank you, Mr. Hegre. Mr. Kumar, do you agree with Mr. Hegre on this? And just to add on to this, we should also keep in mind that US Supreme Court in July 1st this year, in the Trump's case itself, delivered the decision saying that the president enjoys immunity when it comes to when it comes to actions taken within its core constitutional authority. So do you see an expansive judicial review kind of saving the day in the US, or even if you were to bring in the context?
See, I don't think so. And I quite agree with Sanjay's point. I'll come at it from another direction. The direction that I'm coming from is that this is not something which is a narrowly tailored legal power to be used in specific contexts. Even judicial review as such cannot possibly say that a particular decision should be taken in only one particular way. And again, we are talking about judicial review about things like whether a license should be granted or not, right? This is something which is, like I said, at the heart of this power. There is something which is political, which cannot be reduced to something which a legally trained mind can easily say this is legally acceptable, this is not legally acceptable. There are no standards to say what is legally acceptable. Forget about that. Let's also talk about the other element of mercy. The element of mercy is not something that there is one common, inalienable, unalterable understanding of mercy. It is going to be something which is specific. And I think Sanjay very beautifully highlighted it. The fact that an Abdul Kalam might say, why is it only poor people are being hanged? Or a Pratibha Patil may say, I don't believe in the death penalty. But a Pranab Mukherjee may say, I'm okay with this. We have to account for the fact that the people we put in charge of these high offices, and when I say we, I mean as the electorate, whether directly or indirectly, are going to have certain views about these things. And these things cannot be reduced to a simple legal question. Yes, you can say procedurally it was a wrong thing, which is fine, which is what the Supreme Court has done in the context of Epuru Sudhakar and other cases. But the Supreme Court cannot say there is only one acceptable standard of mercy, or there is only one political set of cases where this is allowed, everything else, because those are not legal definitions. Those are not things judges know how to decide by hearing two parties argue on legal definitions. So I would say this is not something which is judicially reviewable at all, let alone the question of whether there should be judicial review. Right? It's a bit like the judges trying to say whether a dam height should be 60 or 65 meters. It's not something that you as a judge can decide without knowing and understanding engineering requirements and all of that. So, and I'm coming at it from a different perspective. I don't think such matters should be judicially reviewable, except where you have very clearly said there is a procedure to be followed and you haven't followed that procedure, then you can say follow the procedure, if at all. But you can't, at the end of the day, say mercy should have only one meaning under our constitution and our law, or political reason can only have one meaning and not the other, or this only counts as valid political reasoning and this doesn't, because it's not possible. You cannot judicially say this is the only way to do this.
Right. Right. Thank you, Mr. Kumar. If we could now talk a little about the activism that we are
Hello?
seeing in United
Can you hear me?
You're audible.
Okay.
Am I audible?
Great. Go ahead.
Yes.
So like I was
Yes. There's a little bit of a lag, I think.
Okay, great. So now if we could talk a little bit about the activism, the growing activism that we see in the United States regarding the increased involvement of the Congress when it comes to clemency decisions. For instance, the Protecting Our Democracy Act was reintroduced in the Congress last year, which basically requires the White House and the Justice Department to disclose the materials on which the president relies on while making such clemency decisions. Basically, the act envisions the setting out of consistent standards especially when it comes to disproportionate sentencing cases. Do you believe that this could be a viable reform? Mr. Hegre, if you could go first on this, please.
Well, the you can legislate anything, but if uh, if the president were to exercise his clemency powers the way that they currently do, at best the legislation could again be taken as mere guidance. Okay, take into account these things. A president may very well say, I've taken into account these things, and I still think it's a case for mercy. Or he may say that I've taken into account all this, and I don't find it a case for mercy. So there is something special about these powers, simply because it speaks to the basic humanity inherent in all of us, both uh, he that exercises it and he or she that receives it. Uh, it's like this, that uh, there can be cases where there there is a there is a penalty imposed and the legal process is over, but yet evidence comes out, and then there is no way of reopening the judicial processes for whatever. In fact, mercy jurisdiction, a presidential pardon was even given, if memory serves me right, by Jimmy Carter to a doctor who had treated John Wilkes Booth after he assassinated uh, President Lincoln. So, mercy jurisdiction has been used much after people have just left this world. Therefore, you may legislate some standards, but those standards will also still remain just standards and guidance. It can't be that if that guidance is not followed or not observed, that there will be somebody to second guess the exercise of that power.
Right. Thank you, Mr. Hegre. Mr. Kumar, what is your opinion on this?
This is something that I've sort of realized after a long while of doing this kind of work. No law can prevent its own abuse or misuse, for that matter. That at the end of the day, it is individuals, thinking, rational individuals, who apply the law or choose not to apply the law, or choose to apply the law in a particular way and not apply the law in another particular way. When somebody is determined to break the law, and then I don't mean like an ordinary individual, and somebody in a position of authority, in a position of power, is determined to break the law, there is nothing the law itself can say to stop that. What the law can do is make it more costly or impose certain barriers, but it cannot do it by itself. There needs to be a system of review, institutions, and so on, which can make it more costly, more difficult, more painful, more cumbersome for that person to break the law. And just to give you an example, your local constable has the right to arrest, or the power to arrest. You say right. It's the power to arrest. There is a certain way that power should be exercised. Doesn't mean that no constable in the country of India ever violates this power, right? They abuse it and misuse it on a daily basis. What the law can keep check is, if you do this, this is what can happen to you, the constable who arrests wrongly. If you need to make an arrest, you need to follow this procedure. If you don't follow this procedure, this is what happens to you. So now, if we want to expand it, it is fine to have a law which says declare this, the public should know, all of which is great. I'm not saying don't do that. But let us not see it as something which fundamentally prevents abuse or misuse. And it's also difficult to say, and I think which is also what we've been getting at in this conversation, what is exactly abuse or misuse of a power which does not have clearly defined, this is the only thing you're supposed to use it for and nothing else, right? When we're talking about things like politics and mercy, these are not legally defined, closed concepts which have only one specific set of meanings. They are going to be open-ended. So even understanding what is abuse, what is misuse, is going to be a challenge. In 20 years, somebody might say the best thing Joe Biden did was, grant clemency to his son, Hunter Biden. And in 40 years, someone may say President Trump saved the American democracy by pardoning the January 6th riots. We don't know, right? Today, we don't have that perspective to say, absolutely, that was a wrong decision, or absolutely, this was the right decision. That is something that we can say retrospectively, retroactively, maybe 20 years, 40 years down the line. But that cannot be a basis to say this power should exactly, that like, the scope of this power should be limited to say, be used only in these circumstances, or if it is not in the exact accordance with this procedure, the whole thing is completely invalid. I don't think that is possible. And it's fair that a law should demand transparency from the government, which is always a good. That is a good, but that is not something which will necessarily limit or reduce the exercise of power by the president to grant clemency.
Right. Thank you, Mr. Kumar. If we could now proceed to the last question for the evening, I would like to discuss a little about the clemency process in India. Of course, both of you have pointed out how we have seen presidents sit on mercy petitions when they have disagreed with government advice. Gubernatorial offices have also been at the center of political controversies, as we have seen, for instance, in the release of A.G. Perarivalan, one of the convicts in the Rajiv Gandhi assassination case. Mr. Hegre, what reforms do you believe are necessary in India's clemency process, and what lessons do you think we can draw from the Hunter Biden case?
The first question is, should the power of clemency at all exist? Both Alok and I believe that it should exist. Once it exists, in whom do you locate it? You can't locate it in the judicial system, because the judicial system is the one which has sentenced. Then you're basically asking the judiciary to review it. So it has to vest in someone. It vests in a high authority, which is the president in both cases. The difference being that in India, it's the president who's advised by the cabinet. So, given the nature of the power, one can at best have guidelines, but you must ultimately trust discretion. And it is, let's say, the randomness of things, of life itself, which operates. One president may pardon, another president may not pardon. As I gave you the three examples of the three presidents who approached, Indian presidents who approached the death penalty in different ways. So somebody might quite feel that, if I had done a crime and it had come up before President X, maybe I would have got a pardon. With President Y, I did not. You spoke about the Rajiv Gandhi assassination case. Even there, it was the cabinet which recommended pardon, and the governor of the day in Tamil Nadu refused to carry it out. And then it went up and down the ladder before it was finally approved. That the use of pardon power there also was, in a sense, turning a page over a long and painful history. That was exercised much after the LTT had finally been defeated and ended in Sri Lanka. So these are political questions which are not necessarily capable of ordinary review, and they're definitely not of judicial review. All that we can do is to second guess these decisions. But second guessing is, while it is of interest to the public, may not be in the public interest.
Right. Thank you, Mr. Hegre. Mr. Kumar, any concluding thoughts on this?
I think more than the president's power of clemency, I think our day-to-day release of convicts, our day-to-day exercise of granting convicts release for good behavior and so on, I think that needs to be reformed. Because I know the Supreme Court has taken up a case on this. If I recall correctly, a Justice Oka-led bench is looking at this issue. But having had a little bit of interface with the system, I feel that state governments aren't taking their responsibility very closely, because the fact of the matter is, even from, say, Hamilton's time, to go back to somebody who I mentioned in the first part of this, where he acknowledges that the criminal justice system is about inflicting punishment. We are now getting to the position that the criminal justice system should be a reformation system, that it doesn't always have to inflict punishment for crimes committed, but it should reform the individual. And I think that reformation is possible if individuals know that if I make myself more useful to society, that I repent for my crimes, that I show good behavior, that I don't need to suffer this long an imprisonment, that I could actually get out in 7 years and not 14 years. Unfortunately, our system is not working as intended. People are languishing in jails. People who have committed one crime, it may be an extremely violent crime, but who have committed that one crime in the heat of the moment, have regretted it, have never done anything wrong again, have been on their best behavior, are not getting the benefit of clemency or release. So I would say, yes, that big constitutional power perhaps should be used for extreme cases, like maybe the death penalty and so on. But on a day-to-day basis, where when we have thousands and thousands of convicts in this country who perhaps are in jail for valid reasons, but should not perhaps be too long in jail because they can be very important, valuable members of the community and society. I think that is where our criminal justice system should focus on ways of hastening up this process of parole, hastening up this process of remission, and releasing them. Sure, the crimes don't get wiped off the record, but I think for the convict at the end of the day to be released from prison to get the remaining part of their sentence wiped out, I think that would be more important. And I think that is where we should look to reform to ensure that the benefits of this mercy aren't limited only to one person exercising that power of mercy at one point of time in a state or at the union.
Right. Thank you, Mr. Kumar. Thank you, Mr. Hegre. I certainly found this discussion very insightful, and I'm sure our readers and listeners will feel the same way. Thank you once again for joining us today.
Thank you.
Thank you so much, Aaratrika, and see you, Sanjay.
See you. Bye.